in corporate law and IPR from the North Cap University. Mr. Pandey also holds a several certification and has authored articles on non-disclosure agreements, data protection, and arbitration law reforms. Known for his resolution-oriented approach, he is passionate about mentoring legal young professionals in this field. So let's welcome Mr. Pandey, and it's over to you, sir.
Thank you so much, Divya. Uh, First of all, I would like to thank you all for assembling in such huge numbers today. It is indeed a great pleasure to be presenting before you all. This whole presentation, and in fact, the idea was not my brainchild. It's I should give the credit to Mr. Rajiv and Divya Tandon as well. And she has been continuously supporting me in this whole presentation thing. And I hope today's session is knowledge worthy and everybody is able to take away something from this which helps them in their legal career. I know contract drafting might sound a little boring to some of us, but trust me, when your first paycheck comes, it will really pay off. So make sure to pay a little attention to what is being discussed today. It is definitely a great opportunity, an opportunity which I personally craved when I joined the whole lawyer career, because I was always looking for learning opportunities in terms of corporate mergers, acquisition, and somehow the resources back then were just failing me. But this whole information technology boom, it is indeed a boon for us to learn and interact with each other, network a lot, and that's all that I want to say. Let's start with the presentation. I think can I share the screen, Divya?
Yes, sir. You can. You have the rights.
Okay. Okay. So what today we will also be doing is that I have a sample NDA in my hand, which I'll try to show you certain provisions of the same in case I'm trying to explain something and we are missing a point there. Just a second. So whenever usually I start a discussion with respect to contracts, I usually start with a story which was told me when I started whole contract negotiation thing. It was a story of a great ruler, uh, maybe not so great in terms of humanity, but nevertheless great. So it is a story of Changiz Khan. What happened was that during his whole campaign, he was trying to conquer the region that was territorially within nexus to him. So what he was facing some difficulties with respect to one certain kingdom. The kingdom had great walls. They just won't come down. And without those walls coming down, Changiz Khan was almost unable to penetrate into the walls. So he laid siege and his army continuously sat behind the walls for 10 days, but nothing would happen. So what he did was he said he sent a journal to the city saying that I want to come to a truce with you. Let's come to an agreement. Send me a representative of you. The city was also somewhat in favor of a truce. So they said, okay, we will send our representative. And a representative went. So during the talks, Genghis Khan said that our army will wind up from your city and we will leave you to peace. But there's one condition. We would require you to give all the cats and mices that you have in your city. Now, interestingly, the city said that we couldn't be more happier. Just take all the cats and mices that we have in our city. In night, what he did was he assembled all the cats and mices that were given to him by the city. He put oil on them and set them on fire. The pain animals who were in pain immediately started running towards the castle. In the process, they burnt half of the city and also gave the location of secret passes through which the army could besiege the whole city. And as such, Genghis Khan was able to conquer the entire city. So when it comes to negotiation, whenever we are giving away something, we need to see what consequences it might entail. It might look very small, very non-crucial from a reviewer's perspective, but also think from a litigation perspective, what it could entail to you if this goes to court. So that's an important aspect. When it comes to non-disclosure agreements, what you would see is that the whole intellectual property driven era we live in, it required some sort of protection. NDAs were not very much in force before 1800. It is an invention that has come recently after 18th century. You would not find a lot of NDA behind that particular century. So in 18th century, what was happening was that in Paris, the chefs, the innovators, they were trying to see how they could protect their whole recipes, their inventions, their intellectual properties, but they were unable to find any ways because in terms of enforceability, there were no laws. So what they did was they brought the Contract Act into their favor. They started drafting provisions of this nature, which later came to be known as non-disclosure agreement. What we have today is essentially a 200-year-old document which has seen substantial amount of modifications. Now, a lot of people argue that NDA is just a small document. Maybe it should not be given that much value. I would rather speak otherwise. If you do not give value to your intellectual property, or if you do not value another person's intellectual property, the chances are the definitive agreement would not be honored as well. So whenever you are trying to share confidential information or trying to receive confidential information, there is a big factor of both the parties acting bona fide. When we have these both the factors, you will see that negotiations, even during the definitive agreement phase, they go pretty well. So just give me a second here. Screen share हो रहा PPT. Yeah, I hope everyone can see my screen.
Sir, are you presenting an agreement?
The PPT I'm presenting.
No, the PPT is not showing.
Just a second, maybe it's loading. Yeah.
Yeah.
I hope it's visible now.
Yes, sir.
Yeah. So non-disclosure agreements, they have a lot of provisions, but what are the provisions that ideally we should be giving little bit of importance? Now, this entire session, I would try to focus on those initial provisions that you should be focusing on, and what are the provisions which are rare but nowadays seen in the agreement. So my discussion would include what are the types of NDA. Currently, we have three types of NDA. It's single party receiving NDA, disclosing NDA, where we are the persons who are disclosing, and the third is mutual, where both the parties are mutually disclosing confidential information to each other. Then we will discuss some usual clauses in an NDA, definition of confidential information, of course, how it needs to be crafted. Then something which I value a lot while drafting or negotiating an NDA, which is purpose. Then comes the term clause, how long this whole agreement should be binding upon the parties. Then comes one of the most important clause for, I would say that this is one particular clause on which if I spoke even for 3 hours, it would be less. That's called mandatory disclosure. But I'll try to cover it in very short here. Then, of course, return and destruction. Then we will discuss some trending provisions which I have recently came across in an NDA. I have also included this in the book that I am writing currently, and I have found that even NDAs have evolved a lot. What we knew 2 or 3 years ago, you might not be seeing that after 1 or 2 years. So that's why I have used these things as well. Then there are certain restrictive provisions. This I would say is rather an advanced version of provisions that are recently being put into NDA. Not an absolute thing, but you might see that certain merger and acquisition transaction, or as a matter of fact, a lot of banking transaction where markets is involved, you'll see these provisions to be routinely used. Then as a whole bonus point, I'll also share you how we should be ideally be negotiating an NDA, how to do a preparation and how to execute your preparation. So just to the basic understanding of everyone, what information can be received under an NDA. Now, you would have seen that a lot of times a company goes to the bank and says that we require a certain amount of loan from you. So the bank would say, okay, we can provide you that loan, which might be in millions, but you have to disclose certain things to us. Now, the company would ask, what are those things? Well, ideally, they would say that, okay, give us your whole financial information, how much was your turnover, and how your company is performing, what are the predictions, and in case of merger and acquisition, what company you seek to acquire. Now, obviously, these kind of information would fall under the category of confidential information. And the company which is disclosing this to a bank or another entity, as a matter of fact, would require these things to be covered under an NDA. Similarly, when we talk about intellectual properties, you would see that in a lot of cases where assignment rights are provided or industrial patents are being provided to another for use or processing, then they would require them to sign an NDA so that these whole industrial designs, patents, or inventions are kept secret. And third category, I'm assuming that most of you are aware of, it's trade secret. You might have come across this in your intellectual property classes. Obviously, a lot of things fall under the category of trade secrets. Sometimes it's recipes, sometimes it's a form of art, and how it's being performed, it might very well come under the category of your trade secrets. Then the fifth category, it's software and tech, where what algorithm was used in developing something technical, and what application is to be used to modify something or maybe to run something. It might definitely fall under the purview of confidential information. So the list that I have presented here is not limited. It's like much more vast than this. We cannot say that this is very exhaustive list. Oh, definitely, you would find a lot of other things that would very well be included under the purview of confidential information. So the definition of confidential information. When we talk about definition of confidential information, a lot of people say that anything that the other party is disclosing you after the NDA is signed should be a confidential information. I would rather disagree. No, that should not be the case. Uh, the purview of confidential information should be defined very strictly. If you are the person receiving the information, you are handling fire. Now, while handling fire, you cannot be very naive. It is rather prudent to see that how your whole confidential information is marked. First of all, see whether the information that was disclosed to you prior to signing of the NDA, that is being included in under the purview of confidential information or not. Secondly, see if the information that will be disclosed to you during the course of negotiation, is it going to be marked confidential or not? Because if it is not marked, then you and your employees, they just have to assume that anything that is coming through that NDA is confidential and should not fall into the hands of person who are not evaluating the transaction. Now, to give a basic understanding, people who are evaluating the transaction are the people of the company uh, to whom the confidential information is supplied, so that they could check whether the deal is feasible or not, or whether they want to proceed with the transaction or not. So this could be the director, officer, or employees. The list could be much more broader. I could even say that some people, some companies tend to bring auditors and legal advisors, consultants within the category. And that is fine as long as these people are really working on the transaction, and the company which is disclosing this information to their employees exercises certain amount of control over them. Because if there is no relationship of principal and agent between them, or an employee and employer, you cannot tie the company with the responsibility. So make sure that these things are pretty much there in your NDA. So the third thing is that information should always be in relation to the purpose. When I talk about purpose, what do I mean is that what is the deal that is going on between the parties? If it is a merger and acquisition, then your purpose should say that the receiving party is receiving information for the purpose of evaluating acquisition financing to the disclosing party. If the purpose is too broad, then obviously it will create vagueness. Now, obviously, not all the information that is provided to you would be in connection with the purpose. If this carve out is there, then obviously you will not be under an obligation to protect information which is not in relation to the purpose. However, I would say that for a safe side, anything that is received by you after the signing of NDA, just consider it confidential information for the safe side. Now, under the definition of confidential information, lately I have seen a trend that a lot of parties are trying to include personal data. Say they will include confidential information, personal data, by saying that we will be disclosing, that disclosing party will be disclosing the receiving party certain client in data, or maybe employee charts, and that would automatically fall under the purview of personal data. If you see anything like this, you should ideally cross check with your business team who has asked you to review the NDA if you foresee receiving these information. The reason being, as soon as we receive personal data, we become subject to data privacy regulations. It could be GDPR, it could be India's Data Privacy Act, and that would add an additional layer of obligation on your organization, because now you have to also make sure that in addition to what you were generally complying with respect to the NDA, now you are also complying with respect to the data protection. So not all confidential information would, not all information that is supplied to you by the counterparty would ideally fall under the ambit of confidential information. Why so? It is quite obvious that some information, uh, any information, as a matter of fact, which is already available on the internet or public domain, that cannot be regarded as confidential information if third parties already have decent amount of access to it. Then your whole thing dissolves. So these are the four exceptions you will always find in an NDA. If not all four, at least three of them you will find in an NDA. So first is information that was already in my possession. So if you are a receiving party, you will definitely make sure that this carve out is there, because in a lot of cases, for example, tech companies, uh, they sometimes try to offer services to other companies that say that we have developed this software, and this uses this algorithm. While as the company has already received another bid from another tech companies which says that this is our algorithm, and both the algorithm happens to be the same. So if that confidential information which was received from the another company, it was not on confidential basis, then it becomes an information that is already in our possession. As a matter of fact, when you see that a lot of banks or financial institutions, they carry out their own researches and make their own flow charts, and sometimes these information that is supplied to us are already on our flow charts. So under those circumstances, the information which was already in our possession goes outside the ambit of confidentiality. Now, second is information that is received from a third party subsequently. Now, if the parties have already entered into an NDA, and it so happens that at a later point of time when the NDA is in force, a third party comes to your organization and says that I have so and so information, and I'm looking for so and so service, and such information was supplied to you on non-confidential basis, then obviously this becomes a decent exception for you. Then lastly is the information independently developed. Now, say after you have signed the agreement, but this information was not in your possession earlier, neither it was supplied to you. But during the course of 2 or 3 years, your employees managed to develop this information on their own, and they did not use the other party's confidential information in developing this. This would create a decent exception. So what generally I have seen as a market trend, these four provisions, the four exceptions, these are not a matter of controversy always. What the other party would do is that they will simply insert a carve out saying, okay, if any of these exception is there, then you ought to prove it in the event of dispute before the court of law, which is fine, because uh, the burden of proof basically would fall upon the person who is trying to assert that fact. So in the case of your company, which says that we already have this information, they would eventually be asked by the court to prove the fact to a certain extent, which is also the preponderance of probability doctrine. Now, while receiving an NDA, there would be certain obligations that would be enforced upon you. Uh, Now, these obligations would not be just about keeping the information confidential. It would extend to how you store the information, and what are the degree of confidentiality you maintain for that information. So you would see that the person sharing confidential information would say that you are required to keep it separately from your usual systems. Occasionally, they will say that it should not be accessible to employees other than those who are evaluating the transaction. This is also kind of good provision which should be there when you are disclosing party. You will understand that this is an important aspect, because you would want your information to be kept safely. Now, the another obligation which I have come across is that the receiving party, it is required to maintain a list of people who have received that confidential information, so that in case there is any breach, uh, they could ask the list of persons who had, so as to pin responsibility on a certain person. As long as you have internal controls in place which could state that, okay, this employee accessed the information, or we have provided information to this employee on this date, this is also fine to accept. Yeah. So third responsibility, which I think more or less I've discussed, is sharing the information to your representatives on a need to know basis. So this is a very common terminology that you will find across in an NDA, which is need to know. Not every person in an organization has a need to know the confidential information. Only the person who are directly involved in the deal, who would be advising the organization as to whether to enter into a transaction or not. They are the person who fall under the category of need to know. Every other person uh, who has nothing to do with that information should not have access to the information. So when I talk about disclosing uh, party, what should be its preference when it comes to NDA? Then obviously protecting information is paramount. But at the same time, since disclosing party is taking higher amount of risk, sometimes they try to dictate the jurisdiction. Now, this would always depend upon uh, we could say that which party is more desperate to get the contract concluded. Say if the other party is in need of finance and the bank says, no, I want this jurisdiction, obviously the other party will say, okay, as long as the finance is being provided on time, I'm agreeable to this jurisdiction. On other cases, where the party is itself bringing good amount of business to a bank or another institution, then that party would say, no, I have registered offices in so and so place, say Delaware, New York, California, and hence I want this specific jurisdiction. So disclosing party would, at least in 60% of your NDAs, will have an upper hand when it comes to dictating the jurisdiction. Now, whether you want to agree to arbitration proceedings or not, that is an entirely different story. That should ideally depend upon what has the organizational experience been with arbitration. Some organizations prefer it, others definitely do not. But the parties could definitely come to a mutual understanding whether arbitration or courtroom proceeding is going to be fruitful. Uh, in terms which are in favor of arbitration, I would definitely say that one particular term that favors them is that the proceedings that happen, they are only between the two parties, so not a lot of crowd has access to those proceedings. However, when it comes to courtroom proceedings, it's not always that easy to ask the judge to make it in camera, so that your whole proceedings are going on between only two of you. So that's one thing which I have found a little bit in favor of arbitration. So now, another point with respect to disclosing parties, that uh, we try to restrict the representatives of counterparty, which is the receiving party, to certain individuals only. For example, any individual which does not have employment or principal agent relationship with the receiving party. Now, they are a possible threat for us, because if they disclose any information in an unauthorized manner, the company would be under very limited liability. So what we do is that we insert a carve out. Okay, you may disclose confidential information to service provider as long as you agree to be liable for any breaches that are arising out of uh, the unauthorized disclosure by such representative. So this is how you could mitigate the risk when you are a disclosing party. Now, obviously, another aspect is what to do after the whole NDA is signed, transaction is completed. How long should I be keeping the whole confidential information confidential? It should obviously not be a perpetual term. I should not be under an obligation to protect it, a piece of confidential information, for 100 years. So the standard market practice which I have came across is that confidentiality obligation lasts for a period of 2 years. Obviously, this does not mean that you start publishing your counterparty's data after 2 years. It's just that these obligations would last you on for 2 years. Any accidental breach or so that happens, which is basically not covered under your retention policies, there would be a safeguard available for you. Now, as a disclosing party, how do I bind it? So when I'm a disclosing party, I would go to the term clause and says, okay, you are uh, having the confidential information, or your the term clause is going to expire after 2 years. What you are supposed to do is that as soon as those 2 years expire, you are required to delete all the information that we have supplied to you, or return it, the hard copies, to us, as the case may be. Now, the other party under such an obligation would obviously honor it as soon as the obligations are complete, mutual obligations have been performed, or a definitive transaction agreement has been signed. The confidential information would be deleted or returned. So even this deletion or return, there is an exception. Not all information needs to be deleted, and not all information needs to be destroyed. So you would ask, why should we not delete other parties' entire confidential information? The reason is that sometimes there are laws that prohibit you from deleting those. For example, say there is a certain provision, or say there is certain information in which is part and parcel of the confidential information, which is incriminating in nature. Now, as soon as you delete those, you become a kind of accessory to their whole crime. You are trying to delete evidence. Now, obviously, destruction of evidence is already an offense under Indian laws as well as the foreign country laws. So what we say is that, okay, to the extent it is legally permissible, we will destroy your confidential information, but we will have the liberty to retain information as required by law, or automatic archival backup. Now, for big organizations, you would see that a lot of information is being saved in automatic archival backups nowadays. Now, we cannot go into those archival backups and delete it entirely. That is almost next to impossible. That would require going into multiple files, folder, and deleting a lot of data. That's a lot of work. However, as a disclosing party, we can say that, okay, you are at liberty to retain the archival backups, as long as those archival backups are not accessible in regular course of business, which is a fine provision. Both the parties could come to an understanding with respect to that. So lastly, as a disclosing party, what I have seen that they would require an indemnity provision, so that in case of any breach, a certain amount of damages could be claimed from the receiving party. Now, in terms of NDA, I would say that indemnity provision is a hard call. If you are the receiving party, I would say that resist it at all cost. The reason behind resistance is that we are not offering any service to the counterparty at that particular stage. We are simply evaluating the transaction. So there is an aspect of, you can say that it's not definite that it's going to happen. As soon as we enter into a definitive agreement, indemnity provisions would obviously kick in. But if those are not there, I would say that try to port off this whole indemnity provision at the initial phase. If you are disclosing party, you get an indemnity from the receiving party. I would say that it's a feather in the cap. May God forbid something goes wrong in your NDA, that provision will definitely help you. So last category of this NDA is a mutual NDA. Now these NDAs impose mutual obligations on each other. I find mutual NDAs to be a more safe approach, because both the parties act in good faith. both the parties try to honor their obligations. They know that other party is also in receipt of my confidential information. So I should honor it exactly the way other party is honoring it. It is a good approach, but just try to figure out which provision should be applicable to you per se and which should not be applicable to you. On certain occasions, you would see that a particular provision is not exactly falling upon you, but you are just accepting it. For example, a standstill provision. You would see in a lot of cases that standstill provision are being enforced just on one party, despite of the fact that the draft is an NDA. Draft is a mutual NDA. So that would not make a lot of sense unless the transaction's nature requires it. So that being said, these are the three kind of drafts that you would usually come across. So yeah, this is one specific thing that I always try to focus on is drafting the purpose. So when it comes to purpose, we could say that purpose is something that is both the for which both the parties are trying to enter into the transaction. It could be financing, it could be evaluating a tech transaction, providing tech support, as a matter of fact, even acquiring a company, merger and acquisition, so forth and so on. What should be the ideal approach? Now, the ideal approach whenever you are a receiving party, I would with respect to purpose, I would definitely focus on receiving party because a lot of risk falls upon receiving party when the purpose part goes wrong. Now, that being said, we have to narrow down the purpose to the specific product or service that is being offered to the counterparty. If you do not narrow it down enough and you just say that, okay, this is in relation to a business transaction. Now, what business transaction? Now, if you already have, uh, let's say, multiple relationship with this client where they have disclosed you information in other NDAs as well. So how will you know that this confidential information cannot be used there and that confidential information cannot be used here? This creates a big dilemma. Now, that's why whenever you are at receiving parties, we try narrowing it down to the specific part so that our risk is totally mitigated, or if not mitigated, at least lessened by a certain extent. Now, whenever the purpose is very wide, we call it an umbrella NDA. An umbrella NDA is under which any kind of service or product could be offered. A lot of counterparties would ask you to enter into an umbrella NDAs. I would advise you against it. Try to narrow down it to the specific service which you are offering, because you should have the ability to understand whether the service which is being provided, say it's a simple commercial loan which is being provided, do you really need provisions such as non-contact, non-solicit or standstill for that? No. So an umbrella NDA would which originally had these provisions would enforce these obligations even on the small purposes which do not per se require such heavy obligations. That is why we try to avoid umbrella NDA at the very inception itself. Now, linking the term with purpose. So that's the thing which I was saying, that in a lot of cases, the transaction could ideally be concluded within 6 months. But just because your purpose was too wide and your term is too small, now you have a situation in hand that your purpose is fine, but your term has expired. Now, there is no overlapping. You have to either renew the NDA or you have to again enter into a fresh NDA. So always know whether your term clause and your purpose clause, they are in a mutually agreeable state. It should not be the case that your purpose is so wide that the whole project is going to extend beyond 5 years and your term of the NDA is itself 2 years. That would not make sense. The last is that purpose should not be vague. Why? A lot of you might have come across a doctrine known as holding the pen doctrine. So whenever there's also a doctrine known as contra pro frontum, very much prevalent in the market. So whenever we talk about weight purpose, in the event the matter goes before a court, what the court is usually sees is that on whose letterhead it was first made and who actually drafted the whole contract. In case you did the entire drafting and the purpose turned out to be indefinite, then in the event of ambiguity, the whole purpose would be read against your party and not the other party who had nothing to do with the drafting of the NDA. So these are the doctrines which you need to keep in mind before you negotiate whole agreement. Now, this is something that I think I just covered. Uh, the This is the list of persons who are usually acting as representatives of a party who receives confidential information. The disclosing party could always have its own set of representatives who would include people who are going to disclose the confidential information. Uh, as per the recent trend, I have seen these employees, director officers, consultants, legal team, legal advisors, auditors, uh, even chartered accountants, and so forth and so on. These are the people. You just need to ascertain whether it is really necessary for them to have the information or not. As a receiving party, if you choose to share information with them, you also need to make sure that they have some synchronization with the whole transaction. Okay, so this is one particular topic which I said that I could go on for 3 hours and it would still be less. So it's about mandatory disclosure. Now, under the contract law, you might have come across a lot of provisions that which says that agreement should basically comply with existing laws. They should not be against them. They should not be against public policies. Similarly, we what we have here is that somewhat indoctrinization of the concept of how whole law is influencing the non-disclosure agreements today. So uh, this is one particular provision that regardless of whether it's a mutual NDA or a disclosing NDA or a single party receiving NDA, you should definitely have this provision in your draft. The reason being, in the event, uh, let's say that counterparty disclosed you certain confidential information. It so happened was that during your whole transaction, a scam was discovered with the counterparty's certain filings before a regulatory authority. Now that regulatory authority has a knowledge that gets some knowledge that this particular party disclosed certain information to you as well in regard to the transaction during the investigation stage. So what would happen is that that regulatory authority will send you a notice asking you to disclose that confidential information to them because they are currently pursuing a criminal proceeding against them. Now, this would entail that you will be disclosing confidential information to a third party, essentially, which is not a representative. So, this legal compulsion carve out basically it states that if the law requires me to disclose information, I will. A lot of people would argue that this should be an obvious carve out. If Indian government or the government of America or United States ask me to disclose certain information, why should I not be doing that, and why should this be a whole contractual provision? The answer being the contractual autonomy of parties. Now you will see a very strange trend that in certain countries, contractual autonomy or party autonomy is given preference. Even in arbitration proceedings, you might have seen that. Now, what happens is that party autonomy requires that the agreement is honored word to word. Now, say a certain confidential information was disclosed by you to a legal authority or regulatory authority. The other party would contest that it was not done in a manner that was asked to. They would lay down certain criteria, say we were not notified on proper time, you did not cooperate with us on the right terms and right manner. Now, this being the case, it becomes very imperative that you add the carve out of mandatory disclosure. So what is this mandatory disclosure? It simply says that we will not, notwithstanding anything that is contained in the entire agreement, we shall be at liberty to disclose confidential information when it is required by law or a regulatory authority. Other party would, the disclosing party would ask you to insert the carve out that, okay, you are at liberty to disclose it, but you should notify us. Now, you should obviously, we would find that all right, but we have to see whether it is really all right to notify them immediately. Now, let's just assume a scenario where the government has basically raided your whole complex or seized most of your documents. Are you in a position to notify the counterparty in that case? No. Even, for example, in US, there is an offense, they call it the offense of tipping off. So this is recognized as an offense so that one party cannot inform the other party that police has raided my office premises to search evidence, so that other party destroys it. In order to defeat the whole tipping of evidence, we would require that this whole notification requirement, where we notify the counterparty that there exists legal requirement, it should be done to the extent it is legally permissible. So the carve out of, as long as it is permitted by law, is inserted with respect to the obligation. When we talk about mandatory disclosure, you will usually see three kind of obligations that counterparty would insist on. First is notification, second is consultation, and third is cooperation. I'll be coming to that on the next slide. Yeah, so what you see here are the three obligations. Now, I would say the first one is pretty much is market standard, and you could agree to as long as your carve outs are there. Second and third one, when it comes to agreement which is governed by country other than India, I would say that you should read carefully, because if you, when it comes to consultation, it is slightly less dominating, but cooperation, that's definitely a very dominating language in a contract. Now, the cooperation word would require you to join the other party and resist the whole disclosure requirement or the disclosure summons that has been sent to you by the government. Under those circumstances, basically you will be enjoined as a party in a litigation. You would be spending a lot of money on lawyers just contesting that case. And also, if an adverse order is passed against you stating that you did not comply with us with our requirement within time by the regulatory authority, then you are in for a show. Then you will be paying more than even what you bargained for. So always make sure that the obligation should not be so dominating in nature that you are not able to foresee a future expense. Now, future expense could be in turn not just be in terms of money, it could also be in terms of the loss of reputation as soon as you try to join the other party, which might or might not come out as a, let's say, offender, you will see that there is a good scope that public opinion might shape against you. You might lose a lot of business, and reputational consequences are always there. So that's why cooperation or assistance, as soon as you see this word in a contract, you should know that it's going to be a difficult obligations to put through, not only in terms of compliance, even in terms of what happens in future. So cooperation and assist is going to be a difficult one. However, consultation gives you a liberty to follow a certain thing or not. So whenever the counterparty says that, okay, before disclosing the confidential information, you shall consult us upon the scope of disclosure, you would say, okay, I'll invite your opinion, but I'm not bound by it. So this will give you a certain amount of liberty in terms of trying to act on your own. Okay, so this is a rather more restrictive kind of provisions that are in there in an NDA. Whenever you will see that there is a merger or acquisition case happening, these provisions would be blindly put into the agreement. I would say that it's not always wrong to put them, but in transactions which are not of the nature which requires these provisions, you can definitely pitch for deleting them if you are from the receiving party, of course. So all these three provisions, I would say, are receiving party centered, more or less, because the obligations will fall upon the receiving party, and they would definitely somehow at a certain level and at a certain extent cut down your liberties. Now, what is a non-contact provision? Maybe some of you might already be having hint what these provisions are. So basically, non-contact simply restricts a receiving party from from contacting employees of the other parties with respect to the whole transaction. They say that, okay, we will designate specific persons, point of contacts, with whom you can discuss this deal, but not every employee should be involved. Now, non-contact provision is beneficial to the disclosing party because they know that their whole organization is not being contacted or being lured away, or the deal is not being taken by uh, your company to somewhere else. So these non-contact obligations are like uh, bread and butter when it comes to merger and acquisition deal, because they would be negotiated at length, and consider it a good chance that you will also end up agreeing to some of these. But when agreeing to a non-contact obligation, what should be your approach? Should you just blindly accept it? Of course not. You should try to restrict it only on people who are in receipt of confidential information, not on your entire organization who has no idea that a certain deal is going on in my organization. Even when we talk about merger and acquisition deal, uh, as soon as resolution is passed and as soon as the company decides that, okay, we'll be doing this, there are limited number of directors who are aware that this deal is in the process of happening. Not all the employees of the organization know that a possible merger or acquisition is happening. Reason very obvious that insider trading could be avoided. So you will see this a lot in cases of merger and acquisition. Now, second restrictive provision is that of a non-solicitation. Non-solicitation obligation basically restricts you from employing employees of the other company, which are basically either in the deal, it could be the senior management, or could be directly involved in the deal. What is the reason? Well, obviously that employee will have first-hand knowledge of the entire transaction or the entire deal. Now, the first insight that would come into the mind of a disclosing party would be that as soon as my employee joins this company, he will espionage all my confidential information and the other party will have leverage. Now, in order to cut down that leverage, we insert a non-solicitation obligation stating that, okay, for a term of 6 months or 2 years, or during the term of this deal, you are not allowed to employ any person who has basically worked in my organization. Now, a lot of people would argue that it's basically against my rights. Even the Contract Act allows uh, says that contract should not be against trade, and even as a fundamental right under 19(1)(g), I am allowed to do that. Now, those might be the cases, but by virtue of legal precedents, what we are now seeing is that these restrictions are pretty much recognized under law. In order to uh, deter corporate espionage, this is not held to be restrictive of any fundamental right or trade. So non-solicitation obligation are perfectly enforceable. Now, what should ideally be the carve out? I mean, as a receiving party, should I blindly agree to the entire non-solicitation? Obviously, no. Just a second. Charger there. So, what should I try to keep out of the purview of this whole non-solicitation obligation? It is hmm. So when we talk about non-solicitation, what we try to achieve is that uh, the approaches that are made by the counterparties employees on their own without us approaching them, they are tried to be accepted. We Not everything should be considered as a direct approach, but yes, uh, as long as we have not directly contacted that employee to come and join our organization, that should be fine. Now, second thing is where we have floated an advertisement in newspapers saying that, okay, this position is vacant, or say I have put it on LinkedIn stating that, okay, this position in my organization is vacant, and other parties uh, personnel comes and join me. Now, that that's we cannot restrict those people who are approaching my company on their own. So this would make a good standard carve out for us. The third restricted provision is called the non-circumvent clause. So it's a protective provision designed to prevent the company from bypassing the entire deal, approaching a third party on a same transaction, and then continuing the whole deal with them. For example, say there is company A, there is company B, and there is company C. The company A happens to be a target, and company B and C, they happen to be the person who are uh, evaluating acquiring them. Now, it so happens that we have first-hand knowledge of that these both companies are trying to acquire company A, but only company B has approached us as of now for financing or say something. Uh, so that company B would say that, okay, since other people are also considering acquiring this company and we have come to you for financing, I would want you not to circumvent me and go and talk to the third party or the bidder or dealer, as the case may be, and continue with the transaction on your own, because you are currently working with me. I am accepting offers from you, but that does not mean that you try to cut off my own deal. So these are the provisions that are pretty much common nowadays in merger acquisition deals. Okay, so these are another three provisions. Uh, I would say that these are rather very restrictive provision. They are not just restrictive, they are extremely restrictive provisions. Whenever you see the word exclusivity, reverse exclusivity, or standstill in an NDA, then you should uh, review the draft very sharply. Why? The reason being that exclusivity provision requires your organization to work exclusively with that one particular counterparty with whom you are signing the NDA. You cannot go around the globe and invite more clients on the same transaction. That becomes a big mess if you are a global organization which works with multiple number of clients, because you never know that the same deal would be approached for by some other person on the same transaction. That's why, and the other deal might also be much more lucrative than the one which the current person is offering. So that's why an exclusivity from a business perspective is a no-no. We try to avoid it as much as possible. If it really does come down to exclusivity provision, we try to have certain carve-outs of our own. I would rather say that since this is whole just NDA 101 class, I would not go into the intricacies of those provisions today itself. Let's keep it as light as possible. Maybe if we ever have a second session on this, we could dive into the whole restrictive provisions and how to negotiate those. Now, secondly is the reverse exclusivity. Now, this would require you not to enter into exclusivity arrangement outside the disclosing party. Now, there's a bit of difference, obviously, but this would also somehow hinder into your business, because now a person who was offering you a lucrative deal at the cost of an exclusivity clause can no longer be approached by you. That's also not good from business perspective. Lastly, I would say this is standstill provision. Standstill provision would ideally require you to not to indulge in sale and purchase of securities of the company with whom you are evaluating the transaction. It could not be just be the company, it could as well be the target whose securities are openly available in the market. Now, when I say trending provisions, I would say that currently non-disclosure agreements are seeing a lot of changes, and every day I come across a new type of NDA. On an average, I deal with around 4 to 5 NDAs a day, but uh, with the whole volumes that I am seeing, I would say that at least one or two would contain one of these provisions. So what are these provisions? One is regarding the Data Protection Act. Now, Protection Act is itself a very wide domain. Uh, it's always a feather in the cap if you are a certified data protection analyst. You are able to provide advisory on data protection provisions. I would say that for any person who is currently pursuing any kind of contract should have a data protection certificate course in their arsenal. It always helps. The reason being, these provisions could sometimes sound very complicated if you do not have a first-hand knowledge of dealing into data protection. Uh, data, data protection will kick in as soon as there is any personal data involved within the definition of confidentiality information. This would require you to follow laws such as GDPR. When it comes to UK, I understand it's Data Protection Act of 2018. When it comes to New York, it's the Graham-Bailey Act, and I think there's a one similar provision for Germany as well. So uh, why we should be cautious? Because whenever there is trans-border exchange of information, laws of different countries can come into application. You cannot just say that I received the confidential information in India, so the laws of GDPR are not applicable. You cannot just run away from the obligations that Data Protection Act brings. So what should be your approach? Either just try to uh, cut down the obligation to the particular part where which you are able to comply. Do not agree to bespoke regulations per se if you do not have a first-hand knowledge of those provisions. Be very cautious when you are dealing with data protection obligations of China, because China have their own data protection act, and their system could at certain places be restrictive. Now, secondly comes the export control regulations. This is also rather something new which we are seeing these days, but uh, you could say that the act has been there since some time. It's just that now we have become more cautious in terms of how we are going to deal with it. Now, export control laws would require that the information that is being provided to a receiving party uh, is not shared with a particular countries where there are sanctioned by the country which is share of whose origin company or citizen is sharing you information. For example, if information of a certain US based company comes to you, they would require you not to share that information with a representative of you, even if that person is representative of you but who is sitting in North Korea. No, North Korea is a sanctioned country. Iraq is a sanctioned country for US, so they would not allow you to share those confidential information to those particular countries where there is a likelihood that such information could be somehow processed for terrorism purposes. So that's one aspect of export control regulation. I would not say that this is the only aspect. It's a pretty exhaustive provision in itself. It provides a lot of legal intricacies. So what should be my approach as a reviewer? I would usually, if unless I have a first-hand knowledge that my certain representative happened to be a resident of these particular sanctioned countries, I could agree to these export law provisions, but it should not be very bespoke in nature. For example, it should not say that you should exactly comply with this in this manner, which is even more restrictive than what law is requiring me to do. The last is restriction on AI. So AI could be a boon, but when it comes to NDA, it has become a bane for us. Why? Now, there is a very smart trend going among individuals is that whenever they see a provision, they would, even in law firms, I have seen that people just take a photo from Chat GPT and say that, okay, insert carve outs in my favor and give me a revised clause. So some of us might not be aware, but Chat GPT or AI tools, they do not fall under the category of representatives or under the category of allowed tools, as a matter of fact. Now, as soon as you insert information, any clause of your NDA or say confidential or information of the other party, you have effectively breached. So why is it a problem? Well, every Chat GPT or a lot of I would say, they are self-capable of storing a lot of information, even keeping the history of questions asked by you. If these apps are capable of retaining a history of your records, they are very much capable of sharing it with the company that owns it. Now, if we are talking about a merger and acquisition deal, what will happen is that the owner of that particular app, uh, that company would have a first-hand knowledge as to what was being processed by you in that. And nowadays there are very good filters that could be put for, say, simply they would say, they would put the filter of merger and acquisition and filter out the information where it is being spoken of. As soon as they see that, okay, this particular conversation is regarding acquisition of a certain XYZ company that is going to happen. Now, what would that constitute? That would constitute an insider information essentially, because now they will have the ability to purchase shares of that company without even processing the data lawfully. This is one aspect. The other aspect is that the receiving party, as soon as it takes photo of any confidential information and puts it on an AI, it has effectively breached the confidentiality agreement. Make no mistake, even if this clause is not there, if you tend to do this, you are in a troubled water, because the information is very much being capable of being placed on market someday by that app, and it will become a mess to argue and prove in a court of law that how it has come into the public domain, because obviously the onus of proof, the burden of proof would lie on the person who's saying that it did not happen through me and it could have been the other places. So that's why I would really advise that unless you have an organization approved AI which is specifically available to your organization and not available to globally, do not use applications for reviewing the drafts such as non-disclosure agreement. Other drafts, I would say it is fine, as long as that those drafts do not contain non-disclosure provisions. But if your draft pertains to any kind of confidential information, I would advise against it. Okay, so now we come to the term clause. How long should the NDA be? The market standard practice is 2 years, or till a definitive transaction documentation is reached. If you are a disclosing party, you could say that, okay, we can agree to termination of this NDA once definitive transaction agreement is reached, as long as that definitive agreement also has confidentiality provisions. This is a agreeable part for both the parties. I do not find it to be very controversial, but yeah, you could definitely come on terms on that. One very important aspect I would say is that just make sure that nowhere in the agreement is your confidential information termed as trade secret. Why? Because trade secrets are required to be kept under confidentiality obligations as per applicable law. That would override your term clause. Effectively, what you will have is a perpetual NDA in your hands, on which you will have to continuously monitor that confidential information does not fall into wrong hands. So make sure that in your NDA, the nowhere it is written that confidential information shall constitute trade secret for the purposes of this agreement. I see this clause very frequently being inserted very cleverly by a lot of organizations. It is, I would say, uh, very legally, legally and fundamentally disastrous if you allow this. So this is one aspect. Lastly, your term clause should not be tied to the exceptions. Certain times what you would see is that the other party would say that, okay, the confidentiality provision should last as long as the information does not come into public domain. Well, that would effectively mean that we ourselves don't know when it will come into public domain, and we are also not aware uh, when it would fall under the other three categories. That would mean that something that you could have negotiated just for 2 years, now you will have to keep perpetually. So that is something to be very careful of. Do not let counterparty tie the term clause with exceptions to an NDA. Okay, this is a return and destruction. I think we have briefly discussed this earlier, so I'll just let this one go. Yeah. So how to negotiate an NDA? Well, negotiation is an art which I can definitely tell you cannot be learned within one day. It is something that you will learn over the time. But what is a good practice? It should be common knowledge. So when it comes to this negotiating an NDA, or as a matter of fact, any draft that with a counterparty, I would say always know what is a must-have for you. What you can allow and what you absolutely cannot allow should be very clear in your mind. Sometimes you would be doing negotiation on the draft, sometimes you would be doing negotiation on the call. You should know what provisions you will agree to in a certain scenario and what you would not agree to. This would give you a chance to negotiate better. How? You will know your exact amount of fallbacks that you have, what you can effectively barter for what. So as soon as you send your first draft after reviewing and the other party request a call, ideally ask them that okay, we can go on call, but we just want to know what are the positions which are conflicting in nature for you. What are the points you seek to negotiate on? And once they provide you the list of points, just figure out what are the points which you could let go, and the points which you cannot let go, just uh, have a good talk with your business line, which has come to you, say the director of that certain department who has approached you for the review. So just ask him whether you would be agreed to taking up these kind of obligations. If he says yes, then obviously you have a commercial sign off to proceed with. If he says no, then you know that this is going to be a dog fight for you, and then the person who can reason better will obviously outsmart the other during negotiation. So for that purpose, it is always important to know your must-haves. Now, second part is, what are the positions that you are willing to let go? Not everything that we put in an NDA is a must-have for us. Some things are like casual, good to have, just favorable. So we retain those. Now, those are the list that you should always be in your knowledge. Sometimes the negotiation of your draft is governed by policy. Some companies have their own policies stating that these are the provisions which we will absolutely not allow in the draft, whereas these are the provisions which are good to have, but we can let go. So have that policy document ready with you. In fact, if you are negotiating the draft, just have a beforehand knowledge. Now, the third aspect is doing a background research on counterparties' line of business, what kind of product or service they usually offer, they purchase, where the counterparty is basically having its registered office. Now, having a knowledge of where the counterparty is registered gives you upper hand in terms of negotiating jurisdiction. For example, say a party is situated at New York, but it wants jurisdiction of Switzerland. Your first argument should be, why do you want it to be Switzerland when you are situated here? There is a disparity. Ideally, it should be New York, or it should be the place where I am providing you the services, maybe India. So this is how you choose to do background research and then later use it during the negotiation. A lot of clauses you will find that are not applicable to IT industries but have been just blindly put in the agreement. If you have a first-hand knowledge of what other parties' line of business is, those clauses could be avoided. Yeah. Lastly, it is important to know what is a business call and what is a legal call. When I say business call and legal call, I am talking about whose decision would be superior to whom. Certain times the business is too desperate to just see the deal through. However, the clauses are of the nature which only legal could understand, that would have a very devastating effect in future in terms of compliance. As soon as you figure out that your company is incapable of complying with a certain provision, make sure that you flag it to the business and provide them the reasoning and tell them that if this happens, then we would be under this scenario, and there is an indemnity provision or liquidated damages provision, as the case may be. So those are the things you need to know, and you also need to tell the business at certain times that this is not a business call but a legal call, where your opinion will override business team's ability to go with the deal forward. And once you know these bifurcations, you will be able to provide a better reasoning during your agreement. So basically the fight is always between uh, you and the other party's counsel, but ultimate beneficiaries are the signing entities. But you should ensure that your signing entity is not at the verge of any kind of risk during these negotiations. So to conclude, I would say that NDA has turned out to be an amazing tool lately. Uh, it has its beauty and it has its burden, but what I would say is that a lot depends on how bona fide both the parties are. What I have usually seen in my line of business, people try to honor the confidentiality agreements, whether they are with respect to employment or whether they are with respect to transactions or otherwise. Uh, NDA is not just going to be a small tool for you. It could be a bread and butter for a lot of people who are working throughout the globe supporting just this division. In India itself, you would see that there are dedicated teams of NDA with several banks who support the bank continuously throughout the day on non-disclosure agreements. There are immense amount of job opportunities with respect to contract negotiations, and NDA forms the basic layer of the contracting world. NDA is something which is expected least of you, despite of the fact that it is going to give the most to you in future. So whenever you see that uh, there is a certain contract with respect to NDA, or there is a certain contract which has confidentiality provisions, you can always go back and check which provisions should ideally be relied. I'll of course be sharing these slides with you. You can definitely look into these whenever you want. But I would say that do not take your NDAs lightly. These drafts will someday help you negotiating even more complex drafts, maybe master service agreements, maybe SaaS, maybe merger and acquisition, leverage finance acquisition agreements someday. So this is something which will create your base. It really helped me in my initial career years when I was struggling with drafting agreements. But today I could say with a good amount of confidence that it is a big step stone for having tried to learn an NDA. I wouldn't say that I'm an expert. No, it's a continuously evolving field like law, and it will require attention from you as well. Nobody can say that the drafts that we are negotiating today will remain the same. A lot of things will change. However, what today I have discussed with you happens to be the provisions which have more or less been consistent in terms of negotiation. For example, the confidential information clause, the purpose clause, the representatives, the exceptions, legal mandatory disclosure, retention term, so forth and so on. I've also discussed with you certain restrictive provisions, which I'm sure you should definitely go back, give it a look how these provisions are. Try to draft some on your own and see whether you are able to understand how it's restricting your business. It's not something that you will learn overnight, but I would say that after 30 or 40 drafts, it will come naturally to you. A lot of things that you were earlier struggling with would come very easily with you to you. So with this, I would like to conclude my presentation. I hope I have not exceeded my time. Okay, I think I have exceeded it by a huge amount.
No
But
problem,
that
sir.
doesn't
Thank you
matter,
so
sir.
much.
Mr. Pandey, you have given a very insightful picture of these non-disclosure agreements, and your expertise and practical examples truly enriched our understanding of this critical area of law. The clarity with which you explained complex legal contract concepts made the session both accessible and very impactful. We greatly appreciate the time and efforts you took to share your knowledge with us, and we look forward to applying the valuable takeaways in our work. And thank you so much once again. Thank you.
It was a pleasure, Mr. Rajesh Changa. I'm really happy that you invited me for this call. I'm just a little sad that the time constraints were just too much for me. The topic is inherently very big, and despite of how much I tried to cover it,
Absolutely, absolutely. The topic was very lengthy, and you took absolutely perfect timing. There's
thank
no extension of time.
Thank you so much. Actually, I had one more session prepared for your audience. It was literally about draft, reviewing the contract live, maybe some other day.
Absolutely, absolutely. We will invite you, and we would be happy to invite you once again and time and again.
Because I would be failing in my duty to correctly guide people if they really want to negotiate any. Because as a matter of fact, I've wanted at least one or two of your audience to join my organization in future in case NDA was something that they found lucrative. So that's
Absolutely.
really helpful.
So, Divya, it's up to you now.
Yes, sir. Thank you so much for imparting such great knowledge. I would request anyone if someone has any question or doubt about the session. I guess, is there anyone?
I
Okay,
think
so
there should be no doubt about this whole topic. Apoorv has defined and explained everything so clearly. I think there should not be any doubt to anyone, as far as I think.
yes, sir, I was coming to that only. I think there is no doubt because of such depth in every topic he has explained. So thank you so much, sir, for joining us and imparting your knowledge. We would like you to some other day give us more knowledge about NDAs. So thank you
I'll
so much.
also prepare a list of interview questions that are usually asked with respect to NDAs, or as a matter of fact, a lot of drafts. So that would really help your audience in cracking interviews in future.
Thank you. Thank you so much, sir, for your time and effort.
Thank
Thank
you,
you,
sir.
everyone.
Thank you. Have a good day.
Everyone.
Thank you.